Free speech is vital for a functioning democracy and for our knowledge to evolve and develop over time. Free speech enables us to critique and criticize the government and hold underperforming politicians to account. Without free speech, people must adhere to government talking points, creating a hollow echo chamber. Without free speech, incompetent and corrupt politicians can thrive. Without free speech, we cannot challenge the status quo, and our knowledge becomes stagnant. Unfortunately, the Albanese government and the ALP have seen fit to attack free speech through their so-called Misinformation Bill. The bill is so egregious that even Human Rights Commissioner Lorraine Finlay has criticised it. In this video, I'll dive into what the bill aims to do and why it is so abhorrent. Now, the goal is evidently to target so-called misinformation on social media platforms. The bill exempts the government, universities and the media from its own provisions, enabling the government to go out and spread misinformation itself. This should be no surprise, of course, given that Anthony Albanese once flippantly remarked that if he were to become dictator, he would ban social media.
I'll give you the perfect world, okay? You are dictator for 5 years. What do you do?
If I could do something, maybe ban social media.
Because why? What worries you about social media?
Look, I think a couple of things. One is keyboard warriors who can anonymously say anything at all.
So with this in mind, let's look at the bill and why it is such a massive problem. And if you've got any thoughts about it, well, do let me know that in the comments below. So let's start with what the Misinformation Bill aims to do. Well, it effectively would deputize social media companies to go out and take action to suppress and eliminate so-called misinformation. The relevant regulator, ACMA, wouldn't itself send jackbooted goons to social media influencers to harass them. Rather, it would get social media companies to do it on its behalf, at least metaphorically. Now, to be clear here, the misinformation underlying this bill is so incredibly broadly defined that there are massive problems, and that's something I will come back to. Now, the way the bill would get social media companies to suppress so-called misinformation is in two ways. First, ACMA would be able to collect and then publish information on misinformation on those social media platforms. So, for example, if misinformation were rife on YouTube, then ACMA could collect information on that and then publish that information to name and shame those companies. In so doing, it could make the company look less trustworthy and as a result potentially undermine its business model by making it less attractive to advertisers. Second, ACMA could force social media companies or bodies representing them to publish codes of conduct to govern the suppression of misinformation. Those codes of conduct could then ultimately become enforceable. If the body or the entity were unable to come up with a code of conduct, ACMA could come in and create one itself. These codes must provide adequate protection for the community from misinformation or disinformation on the services. Now, clearly, if they fail to do so, then ACMA could step in and provide such a code of conduct. ACMA could then require the companies to comply with that code, and if they fail to do so, ACMA could issue them with enforceable undertakings, and if they fail to comply with those undertakings, they could be penalized. And therefore, in so doing, ACMA could encourage companies to go out and suppress so-called misinformation. Now, at a superficial level, people might be thinking, what's wrong with suppressing misinformation? Misinformation is bad, let's get rid of it. The big problem is how it operates, the types of speech that will be suppressed that are actually real, genuine speech, and the fact that it is so overbroad. So let's go through some of these problems. I'm just picking some of the biggest ones that occur to me. The first one is how you define misinformation. The bill defines misinformation as false, misleading, or deceptive information that, quote, is reasonably likely to cause or contribute to serious harm. Now, there's actually quite a bit to unpackage there, because within all of those components, we have issues. Furthermore, information from government, universities, or the media would be exempt from this and effectively deemed to not be misinformation. I'll come back to that later. Now, at a surface level, the definition sounds somewhat palatable. What can be wrong with suppressing false information, for example? But there are some problems. The bill doesn't define what is false, misleading, or deceptive. False according to whom and at what time, according to what measures. Misleading according to whom? Deceptive according to whom? According to the government? According to a fact checker? Do you trust the fact checkers? There's a whole lot of questions that are really left unanswered. Now, clearly legislation will have a tough time answering those questions, but perhaps in this case legislation should not be stepping in into such a contentious area. Now, of course, there are major issues underlying this. The first issue is that this gives rise to enormous power for a cottage industry of so-called fact checkers, which themselves are not necessarily accurate, not necessarily trustworthy, and not necessarily impartial. We saw this, for example, during the voice debate, where there were disputed fact checks put over Peter Credlin's commentary. Those disputed fact checks pertain to how long the Uluru Statement is. There was a live debate about this, because the same person might say it was 1 page and also say it was 18 or more pages, and therefore the length of the Uluru Statement was a live issue that was up for debate. However, a fact-checker weighed in on one side of the debate, even though there were arguments for the other side. This meant the fact-checker was really making a political decision here. One can also see during the Voice referendum as yet another example, the government liked to claim that the Voice was merely advisory, and it was misinformation to claim otherwise. Misinformation claimed that the Voice would be powerful. However, as I've indicated, if you look at the plain text of the amendment text, well, the Voice would have had power. It would have had power because it would be the only constitutionally enshrined body that could make representations to the government, and therefore implicitly would need to be consulted by the government. No other body would have those same rights, and therefore it would tautologically have more representation and consultation rights than any other entity, because no other entity would be enshrined in the Constitution. Therefore, it would be able to control the narrative because other people might simply not be in the room. The Voice might be consulted, but countervailing views might be avoided or perhaps ignored because the government did not need to consult them. Furthermore, the Voice would have litigation rights because it could allege the government had failed to consider its representations, failed to consult it in the adequate manner, and therefore it could litigate potentially vexatiously if it didn't get its way, something that Thomas Mayo had alluded to. This gives rise to indirect, implicit power. This is still power. It is not merely advisory if there is power underlying the Voice. The government's talking points were clearly false, but the government would wrongly accuse people who raised questions of spreading misinformation. The other issue is that knowledge evolves over time. Things that we believed at one point to be correct might turn out to be wrong. For example, we once believed that the sun revolved around the Earth. Or for example, the theory of evolution was once misinformation. There's a whole lot of things we take for granted now that were once rather contentious. However, by suppressing challenges to the status quo, this misinformation bill effectively keeps us locked in the now, and it stops information advancing. Now, the government might argue that they're exempting universities from its provisions, and universities could go out and create that knowledge. However, knowledge arises from myriad entities, which is something that Ed Husic, the Minister for Innovation and Industry, has himself stressed.
And so when I think of startups, I think these are the problem solvers. These are the people who do things differently. These are the people that force others to think and do things differently by virtue of what they have come up with. And what we need in the Australian economy is that dynamism. We have too many, let me rephrase that. We have a few big companies. I want big firms, but we can't have the same narrow, concentrated number of firms. You inject, and the investors that back you that are here inject vital energy into our economy and to get us doing things differently. And we need to work with you to make that happen.
There are also issues with the threshold requirement that the information in question must, quote, contribute to serious harm. This is clearly an insufficient hurdle, because it doesn't need to cause the serious harm, it needs to simply contribute to it. Therefore, just repeating a piece of information that maybe were in contention would itself seemingly run afoul of this provision. Furthermore, the definition of harm is incredibly broad. It includes harm to the democratic system, public order, Australians' financial health, the Australian economy, the environment, myriad things. It is so incredibly broad. Therefore, the government might argue that if you're going out and questioning its talking points, this might harm the democratic system. They might allege you are spreading misinformation and therefore harming democracy. However, this can arise even when the government itself is spreading misinformation and one is merely questioning what the government is raising. In theory, a third-party arbitrator could determine what is harmful or what is misinformation or what is false or misleading, but like I said, this relies on us trusting them to be impartial. This then leads me to the next problem, which is who is exempt from the legislation. Now, the way this works is that information provided by some entities is automatically deemed to not be misinformation, and therefore the social media companies don't need to take steps to verify that information to ensure that it is accurate, to ensure that it is not false, misleading, or deceptive. Now, the exempt entities are government, media organizations, universities, and the like. What you can tell here is the government is exempting itself from its own misinformation provisions, meaning the government would then legally be able to go out and spread misinformation. And social media companies would not be obliged to go out and police that. They would not be obliged to take down misinformation from the government, which itself is a bit troubling. After all, the government has so much more power than any other private individual, and is supposed to be trustworthy, that you would expect the government to be held to a higher standard, not to a lower standard. This, of course, leads to the major problem, that the government has carte blanche to go out and spread misinformation itself, spread misleading talking points. But if people challenge those, well then that's somehow perhaps caught up as misinformation because it would go against the narrative the government is trying to pursue, and the government would deem that to be misinformation. There are also problems with educational institutions being exempt. Now, historically, educational institutions were simply involved in the generation of knowledge and in research and the like. However, over time, educational institutions have become increasingly politically active. We saw this during the Voice referendum, where universities took sides in an inherently political debate, and some divisions within those universities spread misinformation themselves. There was one institute, for example, that spread misleading information about the composition of the Voice body. They indicated the Voice body would have perhaps equal gender representation, representation from regional areas, would be elected, not selected. But that was simply false because we don't know that information. Under the actual text that would have gone into the Constitution, it said nothing about exactly how the Voice would be comprised. This would be left up to the Parliament to determine via legislation. And this could change over time as the whims of the Parliament changed. Not only that, the government refused to put up draft legislation about the Voice, and therefore we don't even know what the government intended for the Voice to be, and therefore the talking points were simply false. But under the Misinformation Bill, those talking points would be exempt from being considered. Social media companies wouldn't need to analyse whether those were correct, false, misleading, or whatever the case might be. And that's a problem when educational institutions are becoming increasingly political. The news media can also spread false information, either intentionally or unintentionally. We've seen this, for example, with the myriad defamation lawsuits, some of which have been lodged against the ABC, for example. These involve people like Chow Chak-Wing and Heston Russell, situations where the ABC lost, and clearly therefore where the ABC was spreading misinformation because they lost the defamation lawsuit. The government has, like I've indicated, excluded itself from the revisions, enabling it to go around spreading misinformation. This, of course, is telling. It suggests the whole thing is just a massive power grab. The third issue is the bill seemingly incentivizes overreach and seemingly incentivizes social media companies to suppress far too much speech. The bill requires that social media companies develop a code to suppress so-called misinformation. These codes should, in theory, avoid suppressing political speech, but there are some major issues. First, the social media companies would seemingly be under no obligation to report on whether they suppress speech that is correct, that is, speech that is not false, misleading, or deceptive according to the definition. Or phrased differently, ACMA, being the regulator, could identify if or when an entity fails to suppress misinformation as it defines, but ACMA would not observe erroneous suppressions. You don't know what you don't know. If the speech was suppressed and thus unobserved, you might not even know that it was suppressed to begin with. But social media companies would be named and shamed and penalized for failing to suppress so-called misinformation, but there is no seeming penalty for suppressing too much speech. This creates a clear incentive to err toward overreach and err toward suppressing more speech, not less. Second, while the social media companies are obliged to consider whether their codes create an undue burden on political communication, they aren't obliged to consider whether there's an undue burden on other communication, and what is an undue burden requires definition. For example, a social media company who is perhaps incentivized to engage in overreach might argue that demonetizing a channel is not an undue burden, because that channel can still go out and produce content. However, that fails to consider that by demonetizing a channel, that eliminates the person's ability to be compensated for their time and effort, and therefore pay for writers or editors or whatever the case might be as is necessary for that channel. Thumbnail editors, for example, cost money. Video editors cost money. Software costs money. Computers cost money. Everything else costs money. And therefore, if you demonetize a channel, there's no way to offset some of those costs. Now, most channels are actually making a loss. However, a way to defray that loss and slightly reduce it is through monetization. And if you demonetize a channel, then it makes these channels even less cost effective. Overall, therefore, the Misinformation Bill is a complete disaster. It's a clear attack on free speech. My inference is this appears to be motivated by animus towards social media commentators, particularly social media commentators that are perhaps acrimonious toward or critical of the ALP. The bill is not salvageable. There are no redeeming features. There is no way it could be reformed into something that is in any way usable. It should simply be scrapped. It is a clear exercise in overreach. It defines misinformation far too broadly. It incentivizes social media companies to suppress more speech, not less. The government exempts itself from its own prohibitions on misinformation, enabling the government to go out and spread incorrect talking points without people actually being able to be critical of it. This would be a clear power grab. Clearly, this bill needs to be stopped. And if you're also concerned, then probably the best way to deal with this is to vote out the people who support this at the next election.